present here in the US, and good evening to people joining in from India. Thank you very much again, as I said, for being here with us with USIBC's first webinar for 2021. Um, and this is a very opportune time and a very important subject which we want to talk about today, the non-personal data report, which has been released, I think, on the 22nd of December by the Special Committee of Experts, which was created by the Government of India. As you all know, privacy data protection is a hot topic in India and the world over, and India has taken steps to create a personal data protection law in India, and it has been going on for the last 3 years. And USIBC, through its Privacy Working Group, has been very active, engaging with the government, engaging with all the stakeholders for the last 2-3 years. So to continue on that, uh, as I mentioned earlier, on the 22nd of December, the Government of India released the non-personal data revised report. An earlier version of the report was released somewhere in 2019, and USIBC responded on behalf of its members to in the consultation period. The committee, under the leadership of Kris Gopalakrishnan, who was the co-founder of Infosys, has come up with another revised report based on those recommendations with everybody and all the stakeholders provided. So now to talk about that, we have an expert with us, Rahul Matthan. Um, Rahul doesn't need too much introduction, but let me just, for the people who don't know, Rahul Matthan is a partner at Trilegal and the head of the TMT Practice Group of the firm. Uh, uh, for those who monitor the Indian tech policy landscape, Rahul is a published author and a regular speaker across the world on matters relating to emerging technologies and the law. And he writes a weekly column, which I read actively, which is called Ex Machina in the Mint, and his podcast is also called Ex Machina. So if you're not following him on podcast, and if you're not following him on Live Mint on his for his Ex Machina column, please do so, because that is one of the most important pieces of literature which comes out on tech policy here in India. Rahul serves on the board of Trilegal, and after having served many years on the firm's management committee, Rahul, as I said, has advised some of the largest TMT transactions in the country. He has worked with companies across all sectors of the industry, from big telecom operators, ISPs, OSPs, managed data service providers, and has advised on matters ranging from regulatory matters to ongoing business issues relating to rollout of operations. He has also advised on a range of sectors in the technology space, including data protection, outsourcing, e-commerce, new media entertainment, biotech, pharma, and other related technologies. He has advised on new content delivery models for mobile value-added services, regulatory issues surrounding the delivery of electronic content, and legal and contractual issues in global e-commerce. Uh, Over the last several months and years, he has been involved in a number of policy initiatives in the TMT space, including assisting the Government of India in preparing the country's privacy law, working on the OSP reform, which just came out recently, which a lot of you might have seen, and assisting with the preparation of the most recent draft report on the non-personal data committee, which we want to talk about today. So with that, I'll stop speaking and I'll have Rahul take the floor. But before that, I'll ask each one of you to just go on mute and turn off your cameras, and just have Rahul be on the screen. I'll also turn off my camera because Rahul has a presentation to make, and we'll let him be on the screen full screen. The part which Rahul will make today is going to be on the record. So when Rahul speaks, we are recording this session, but once he finishes up his presentation, for the interactive discussion, we will keep the discussion off the record. So with that, let me just go on mute, and I'll switch off my camera. And Rahul, the floor is yours.
Thanks, Abhishek. Thank you, everyone. Happy New Year to you all. And I hope that this year is slightly better than the one that just passed us. I'm going to just make a sort of a quick presentation. Just give me some space for my slides, and if you can all see me, I'm going to spend, the first, I'm going to say 20 to 25 minutes just going through the report. And there's not much in the slides. Abhishek asked me to make slides, and I reluctantly agreed. I just so much prefer talking directly to you. So unfortunately, the slides are not going to be very edifying, but hopefully they'll help structure the conversation. And then after that, I'm happy to take any questions. The other thing is, when I looked at the report, I've sort of taken it apart and put it together in a structure that doesn't really follow the linear structure of the report. So if you are all sitting with a copy of the report with you, what I will do is I will reference the paragraph numbers so that you can go to the paragraph numbers when I discuss the specific paragraph number. And then, of course, I can take it in some other format as well. The reason I do this is because it occurs to me that an appropriate reference is the Star Wars reference. Star Wars, as you know, was shot episodes 4, 5, and 6, and then 1, 2, and 3. And of course, purists will watch it 4, 5, 6, 1, 2, 3. Others will watch it in what they call the machete order, which is 4, 5, 2, 3, and 6, completely eliminating 1, which is a waste of a movie. And so I'm going to do something similar with the NPD report. I'm going to do the machete order of the NPD report, because I think that's probably the way in which we should think about it. And the sort of structure for that is a set of questions, and I think this is the correct order of questions to ask in order to understand what the report is saying. So the very first question to ask is why? Why are we doing this? And the why, of course, was mentioned in the first version of the report. It's reiterated in this version, but in the 7th section, the 7th chapter of the report. And if you go to 7.2, you realize that what the committee is saying is that in the absence of a data, of a regulator so in the absence of a data principle for non-personal data, we've got to figure out some way in which we need to regulate this category of data. And that's the idea. That's the reason why this exercise. And then in that very same chapter in 7.1, there is reference to two things: the rights that are held in the context of non-personal data. And there are two rights that they mention. The first right is the right to derive economic and other value, so maximizing that value for the community. There's reference to the community. I'll get to that in a bit. But the second right is the right to eliminate or minimize harm to the community that results from this data. So the purpose is we've got this category of data which is not covered, non-personal data. And there are two rights: the rights to derive value from that data and the right to eliminate harm from that data. And essentially, that is the why of the report. This is the reason why the report has been created, and this is what it intends to solve. So the next question is essentially the what. And in this question, I'm going to go through some elements of the report that are, I think, critical to understand the way in which it is designed. The first, of course, is the definition of non-personal data. And this is not a new definition. It's essentially, it's a definition that if you take the universe of data and you subtract personal data, which is covered by the PDP bill, everything else becomes non-personal data. But they, in 4.1 is the chapter where they describe non-personal data and the definition of non-personal data. There are two categories of non-personal data that they talk about. The first is data that was never identified or identifiable. And in this context, the examples are things like weather data or industrial sensor data, data from public infrastructure. This is data that has absolutely no bearing, no relationship to individuals, and therefore is not personal in any form. And then the second category of data is data that once was personal data, but that has subsequently been anonymized and therefore been converted into non-personal data. And then they go into various examples of what is non-personal data, and you'll see that sprinkled throughout the report. But very quickly, let's move on to this new definition, this new concept that is created in this report, and that is high-value data sets. So what is a high-value data set? The definition of high-value data set is in 7.6, and 7.6 calls a high-value data set any data set that is beneficial to the community at large and that is shared as a public good. So the natural corollary is that we now have a subset of non-personal data, and that is HVD or high-value data sets, which has this public good purpose. By doing that, I think what the committee is trying to say is that we're actually more concerned about this concept of using non-personal data for public good, as opposed to all the other uses that non-personal data could be put. And you'll see that repeated in several places in the report. So in relation to every HVD, 7.7 says that every HVD has to have a corresponding data trustee. A given data trustee can be responsible for many HVDs, but there must be a data trustee in relation to a HVD. So in a sense, a HVD is actually created. And then to understand what goes into a HVD, in 8.10, the committee goes into this construct of granularity. So it looks at data depending on its granularity and then determines on the basis of that what data goes into a high-value data set or not. So the granularity is essentially raw data, which is just the raw elements of data in a data set. The second is aggregated data, which is that raw data which has then been aggregated, anonymized, lifted to a higher level so that you can see aggregate values. And then the third is inferred. Now, in order to decide what goes into a data set, they've once again looked at it through two lenses. Non-personal data that's collected by a private entity, non-personal data that's collected by a public entity. And looking at it through this lens, and with that, keeping in mind the granularity of data, all raw data that is collected by a private entity, it is only certain specific subsets of that data that could be included into a high-value data set. And if you take the example of a hospital, you cannot take, this is what the committee recommends, you cannot include all patient data into that high-value data set. But you could include some patient data that gives you inferences as to things like obesity or some specific disease that you're going at. And it's the same for public collectors of data. So you've got you can only pick certain data fields and not the whole data set when you're talking about raw data. When you talk about aggregate data, the entire aggregate data, both from a private collector as well as from a public collector, could be included in a high-value data set. And then when you go to inferred data, the specific recommendation is no inferred data from a private collector can be included in a high-value data set. And as far as the public collector of data is concerned, it is only for national security purposes that inferred data will be pulled out. And then before we move away from high-value data sets, it's worth going to 7.8, which talks about how a high-value data set is created. And so 7.8 says, this is a conscious act. This is something that you actually have to do, and therefore it indicates that a high-value data set doesn't exist, but it has to be created. So 7.82 says that a government or a nonprofit organization may request for the creation of a data of a high-value data set in consultation with a non-personal data authority. And so this is now been clarified to be a more conscious act, which does actually involve the regulator. There is more color into that. The regulator is likely to set up some guidelines as to the appropriateness of the data. What is the objectives, what is the size, what are the actors involved, and to me, I thought 8.8 was very instructive in the context of this request to create a high-value data set. The committee says that if you are requesting the creation of a high-value data set, let's say you're requesting ride-hailing companies to give you traffic data, you cannot go to one ride-hailing company and ask for that. You have to go to all major custodians of that data category, which to my mind indicates that there is an active effort to avoid some sort of competitive, people using this for competitive advantage. So you can't just pick and choose your custodian. If there are multiple custodians of data, then you will have to go to all of them. Okay, so I'm now going to move on to the next question, which is the who. I think there are a few actors that we need to talk about. Who is this universe of players? And really, the first actor is someone that we've been introduced to in the previous version of the bill, and that is this construct of a data business. A data business, to my mind, covers pretty much every business, because this is not restricted to category. Any entity, any organization that collects, processes, stores, manages data, which in today's world is every entity, is a data business. To my mind, I think if not now, eventually, every entity is going to be covered under this regulation. But I think it's important to know that unless you cross a certain threshold, you don't require to register yourself as a data business. And so a lot of the obligations, including the, I wouldn't say obligation, but you would be susceptible to being asked to share your data if you're a data business, and not if you're not. So the threshold in this report has been suggested to be in line with that of a significant data fiduciary under the PDP bill. Once again, this idea of conforming across legislations, particularly data legislations, is good because you really don't want to have different thresholds for essentially the same sort of activity that you're regulating. Then, within data businesses, anyone above the threshold has to register. Anyone below the threshold can voluntarily register. And I guess all of this depends on what those thresholds are, and I wouldn't see anyone voluntarily registering unless they really have to. But within data businesses, there are just two definitions that are also important to know. 7.4 talks about a data custodian. A data custodian is the entity that actually has the customer relationship. But this entity could, and often does, hand over some of that customer data to a processor to process. And so 7.5 refers to this concept of a data processor. And the reason why this is important is because data processors are not considered to be custodians under the NPD framework with respect to that data which they're processing. But since they're also businesses, and in relation to a business, it is possible that as part of their business operations, they will generate data, non-personal data that will be valuable in a non-personal data set. I'm just thinking these are IT companies. There could be a useful high-value data set in relation to IT employees. And so they may have to contribute to a data set with regard to that, but not with regard to the data that they are processing for a custodian. And then the final actor in all of this is the community. We've had reference to the community before. The committee essentially keeps roughly the same definition of a community. It's very wide. Any group of people that are bound by common interests and purposes. It could be geographic, it could be just livelihood, economic iterations, hobbies. Anyone could be a community, but the community has to be represented by some sort of an entity, and the entity has to be a non-profit entity. They're clear that it could be a Section 8 company, a society, a trust, any such framework, and that essentially is the community. The last question I want to ask is around the how. So how does all of this happen? Essentially, we're talking about how our data businesses, and particularly the data businesses that require to be registered, how will they be called upon to share data? I want to first go, and once again, this is the machete order of doing the NPD report. I want to first go to 8.5. 8.5 discusses a set of guidelines and safeguards on non-personal data sharing. I think it's important to start with this because right at 1, 2, 3, you can see the heavy emphasis on public good and the fact that this process of sharing should be specific and targeted. This is they're not going to allow fishing expeditions. The idea is you want to create a high-value data set for the public good, and in creating that data set, you have to choose very specifically the data fields that you're interested in picking up, and limiting it to that, and not going into a fishing expedition to just see what sort of data that people have. And then there's a lot of detail on, once again, granularity. There's clear reference to the fact that, and this is in 8, that outside of the public good purpose, everything else is outside of the scope of the committee recommendation. So it's very much focused on public good. The second thing that I want to discuss is 8.6, which actually lists very clearly what shall not be shared. This was referenced even in the earlier report, and 8.6 says that when data sharing involves access to trade secrets or proprietary information, that is not required to be shared. And also when the data sharing is likely to violate the principle, the privacy of individuals, groups, and communities, that is not likely to be shared. How we determine this is actually something that will either evolve or will come down through the regulator's guidance. Okay, moving on now to, I think, one of the more important provisions. This is in the data sharing provision. Data sharing is in section 8. And the purposes of sharing are listed in 8.1, 8.2, and 8.3. There are essentially 3 purposes that the committee recommends. The first is data sharing for sovereign purposes. So data could be requested for national security, legal reasons, etc. And that is something that you're already subject to as a company under the existing law. These requests can only be made by public or government entities. And very importantly, the Non-Personal Data Authority is not going to adjudicate on these requests because, quite frankly, we've got other mechanisms by which these would be adjudicated upon. I want to jump to 8.3, which is data sharing for a business purpose. If you're sharing data between 2 private entities, and I think in the last committee, there was a lot of last committee report, there was some confusion and consternation about this. But this committee report makes it clear that data sharing between private entities is beyond the scope of this committee, and the committee does not make recommendations on that. Essentially saying that if you're sharing data on a contractual basis between entities, that is going to be governed under your contractual arrangements and nothing else. And then in 8.2, they reference what I think is sort of the meat of the report, which is data sharing for a public good purpose. And in this section, reference is made to HVDs, high-value data sets. And that's the reason why I say, even though the definition of non-personal data features right at the beginning of the report, through most of the operational provisions of the report, it's quite clear that the focus is on these high-value data sets. And so for high-value data sets, you can request these high-value data sets for public good, for community use. And the emphasis is on public good, and as a result, individuals cannot request this information. And even if a business entity is requesting this information, the purpose for which that information is used is actually something that is important to mention. The last piece on how all of this works is this concept of a metadata directory. And a metadata directory is referenced in section 6.1 in particular. So 6.15 is the first place they mention it. The 6.1 references the fact that all data businesses are required to construct this metadata table. And so the metadata essentially is data, as you know, which refers to data. This is the names of the fields in a table. The example that's provided is, patient name is metadata, but the actual name of the patient is not. And so there is an obligation on data businesses to create and construct this metadata. That is then given, and it's not entirely clear how, but the Non-Personal Data Authority will maintain a metadata directory. And I think in its ideal finished state, we're going to have some sort of a large repository of fields of data that is available in the country. And the purpose for this is clarified in 6.4, where the committee says that if you look at this metadata, you will have a sense of what sort of data is available on which you could potentially request for the creation of a high-value data set. And then based on that, you can actually make that request and you can create that high-value data set. I wanted to, I promised Abhishek that I would finish in about 20-25 minutes, but I've got maybe 5 minutes to go through some provisions which I thought were interesting. Some for very selfish reasons, and others just because I thought, look, it just talks to the flavor of the report. The first is accountability. For those who know me and who have read my writing, I am a big proponent of this accountability framework. I wrote a paper on this in the context of consent for personal data. And it's interesting to see that in 7.4, this accountability framework has come in a slightly different way. It's referenced as a responsibility for a duty towards responsible stewardship, a duty of care to the community. And this is an obligation that's imposed on data custodians. So the approach is that you have data which is valuable to the community and you must treat that responsibly. But towards the end of 7.4 subclause 4 and the fourth bullet under that is reference to what I call the approach to liability, which I find actually quite encouraging if this is in fact an approach to liability that is going to be replicated across the data landscape in India. And in that section, they're saying the committee distinguishes between active misuse of NPD and accidental misuse of NPD. And it does so to encourage innovation, recognizing that in the process of innovation, accidental harms may be created. And as long as the data custodian has mechanisms to swiftly remedy it, the idea is not to impose liability as a result of that. And this is repeated in section 8.15. There's a liability provision in 8.15. And once again, they come up with this concept of as long as you can swiftly remedy any vulnerability that is found, and if you adopt a standards-driven approach, self-reported, self-audited, those sorts of things, that the liability is not going to be imposed on you. The one final thing that I'm going to talk about is some work that was done, I think, in response to the comments that were received to version 1 in relation to how this conforms with other laws. I think the biggest legislation that needed to be aligned with this was actually the Personal Data Protection Bill. That, as you know, is currently before the Joint Parliamentary Committee. My understanding is that it is reasonably final. But in the non-personal data committee, in the personal data protection bill, the latest draft, the 2019 draft that we've all seen, there was reference in section 92 to anonymized data. What the version 2 of the PDP, the NPD committee, see, with NPDs and PDPs, we're going to keep messing this up. But what the NPD committee report says is that the provisions of 92 are need to be suitably amended in order to give effect to this construct. Let me explain the construct. And then you can sort of see the language afterwards. But the construct essentially is this. Personal data is governed by the PDP bill. If you anonymize personal data, you essentially convert that personal data into non-personal data. And as long as it is anonymized and no individual is identifiable out of that, then that data is regulated by the Non-Personal Data Authority. Now, we all know that anonymization is not perfect. So if either by some action by a malicious party or just some action, accidental action, or if just technology changes and that anonymization is not sufficient, the data becomes identifiable again, then it moves out of the purview of the Non-Personal Data Authority back into the purview of the Personal Data Regulator, the Data Protection Authority. So that's the way in which it is conformed, very clearly saying that anything which is personal is governed by the Personal Data Protection Bill. Anything which is non-personal is governed by the Non-Personal Data Protection Bill. If there's a mixed data set which has a little bit of personal data, a little bit of non-personal data, then they will be treated as personal data. And so wherever there is personal data, the default is that it will be governed by the Personal Data Protection Bill. I think there's one other point in the context of anonymity to mention, and that is consent for anonymization. There is, if you recall, the previous version of the bill asked for explicit consent to be taken before anonymization. This version of the report changes it slightly, and it states that if you are looking to anonymize data, you should provide notice that you are doing it, so that anyone who doesn't want their data anonymized can opt out. And there's a recommendation that an opt-out option be provided. There is a little work in the report on conformity with some of the other laws. So there were questions raised around competition, questions raised around the impact of this on intellectual property laws. All of those have been addressed in the chapter, but I haven't covered that in this presentation. There are a few other things that I'm actually not going to get into. I'm not going to go into the regulator itself. I think suffice to say that the decision of the committee was to create a separate regulator from the Personal Data Protection Regulator, which is the Data Protection Authority. They have their reasons for it. They also recommend the creation of a law. So we're going to see a new non-personal data legislation. And there is also some detailed reference to a technical infrastructure, but I just felt that rather than get into those sorts of nitty-gritties, we'd restrict this discussion to actually the substantive issues. So that's my presentation. I'm happy to take any questions, or I just turn it over to you, Abhishek, to figure out what we do next. Thanks.
Thank you very much, Rahul. That was very thorough point-wise explanation of the report, and I'm sure a lot of our members will have several questions. But before we open up,